All righty, well, welcome. Thank you all so much for joining. This is the Legal and Financial series sponsored by Care Partners and AARP. And so we are going to dive right in. I have Shalonda Smith. She is a volunteer with AARP, and she is also an attorney. And she will be with us today. She's going to give us a brief introduction, and then she will also help facilitate the conversation and answer some of the questions along with Angela. So I'm going to turn it over to Shalonda so that she can give us a brief introduction and get us started. We have a lot of information. And so I'm Ariel, I'm with Care Partners. You probably received an email from myself. I will ask if you can mute yourself so that we can just have a good audio quality so everybody can hear. And then we'll get started. So Shalonda, I'm going to pass it along to you.
Thank you, Ariel. Good afternoon, everyone. As Ariel said, my name is Shalonda Smith, and I am an AARP volunteer. Actually, this is my first volunteer event, and I'm excited about today's event. It's a very important topic that we'll be discussing today, and I hope you are too. So thank you for joining us for Essential Estate Planning Documents here on Zoom. This is the first of a three-part legal and financial series caregiver webinar. As you may know, AARP is a nonprofit, nonpartisan organization with a membership of people aged 50 and older. There are nearly 38 million members nationally and 2.3 million in Texas, and about 400,000 AARP members living in Houston. You may find more information about other upcoming events and volunteer opportunities on the AARP website at aarp.org/Texas, TX. Again, my name is Shalonda Smith, and as I said, I am a AARP volunteer. So we're excited about our special event this afternoon. So feel free to join us for upcoming events and consider becoming an AARP volunteer. So we want to welcome our speaker this afternoon, Mrs. Angela Oginski. She is a certified elder law attorney in Houston, Texas. She'll be talking about essential estate planning documents. Ms. Oginski is a native Texan. She received her bachelor's from Southwestern University, Georgetown. She received her MA from Rayford University in Rayford, Virginia, and she received her Juris Doctor from the University of Houston Law Center and her CELA through the National Elder Law Foundation. Angela is licensed to practice in Texas and Washington. Angela's focus is estate planning, probate, elder law, and special needs planning. Angela is a regular speaker and presenter on the topics of estate planning and elder law at Chevron, Baker Ripley, Kelsey-Seybold, and a variety of caregiver groups. She is currently serving on the Unauthorized Practice of Law Committee of the Texas State Bar and is an active member of the Texas and Washington chapters of the National Academy of Elder Law Attorneys and the Texas Bar College. Everyone, let's please welcome Angela.
Thank you. I am very happy to be here. Thank you so much for having me. Thank you so much, Ariel. This is the series of presentations that we're going to be doing this time. I've done many times for Ariel at the Aberdeen location in person, when it was Sheltering Arms, when it was Baker Ripley, now as Care Partners. I am so thrilled to be able to do this. I think it's one of the most important series education-wise that I can give, because having your documents in order, knowing what the documents do and how they work is so essential for individuals, for their caregivers, for families, everybody. And so let me give a little bit of somewhat of an introduction to what it means to be an elder law attorney. So the difference between the elder law and estate planning is in your perspective, in how you approach things, or how I approach things. So generally speaking, an estate planning attorney who practices primarily in estate planning, they're really concerned with your stuff after you die. An elder law attorney is really concerned with you as you age. And so it's a lifetime approach to your documents. It's making sure that you've thought about long-term care options. It's making sure that you have people put in place to help you make decisions if there are times of incapacity, be they temporary or permanent, right? Just making sure that there's somebody there who can help you manage your situation, and talking about what happens when those things aren't in place, and what are the options for your family when you don't have those documents in place. And so the presentation today, Empower Yourself with Planning, is about empowerment, right? It is about making sure that you are taking the reins, taking control of your own aging process, taking control of your own future and what you want to have happen. And I think it's really, it's like I said, this is my favorite one to do because it's so essential. So I'm going to share my screen. Y'all just give me a second. Technology is always fun this way. And I believe that, all right, so can y'all see my PowerPoint up on the screen?
Yes.
Wonderful. All right, so empower yourself with planning. Estate planning is about control, right? It's about control over your legacy, control over who makes the decisions for you, making sure that you can make as many decisions as possible while you still can. You own a house, you have a savings account, you have a car, you need an estate plan. It's not about tax planning, at least right now it's not, unless your assets are over 12.06 million, which is the individual estate tax exemption, and around 24 million per couple. Generally speaking, I have not had to do any kind of tax planning for my clients. My clients are just not that, this is not the clientele that I work with. I work with people who have modest estates. And so tax planning is not what I do. It's about controlling where you want to be and how you want to get there. And even when the current exemption amount sunsets in 26, it's still looking to remain about 6 million per individual, and so 12 million per couple. So tax planning is not our primary issue. It's control over what we're doing. My favorite, reasons people avoid estate planning. They're intimidated by the process. And one of the things I have realized about this intimidation is that a lot of people believe that they have to determine who gets the china and who gets the silver and where does grandpa's watch go. And it's overwhelming because they're trying to figure out their personal items and every little personal item that they have to put in a will. We don't need to do that. Your will is generally going to be the big things in your life, your big assets, right? When it comes to personal property, if there are specific items, we can put those in the will, but we can also do separate documents for the personal property. So if you have delayed getting your estate planning done because it's just too overwhelming to think of the actual personal property inventory of your house, don't. Contact somebody. Contact an elder law attorney, contact an estate planning attorney, and get this process started. It doesn't have to be intimidating. It's actually very simple once we start. People don't think their estate's big enough to need a plan. If you own half a house, you need a plan. And when I say half a house, all of us, if we are married and our spouses own our house with us, we own half a house. In Texas, as community property, you don't own the house together, you each own 50%. And if one of the spouses pass, the other spouse does not automatically receive that 50%. You still own only 50%, and the deceased spouse's estate owns 50%. So in all honesty, it does not matter how big or small you think your estate is. If you own something, you need a plan. Does that mean that you have to have a will or a trust or like all these documents? Maybe, maybe not, but you still need to have a plan in place. And planning is more than just the will, right? It's far more than that. It encompasses so many greater ideas than just putting a will down on paper. People think it's too time consuming or too expensive. When you don't do it, it's so much more time consuming and so much more expensive for your family. Things that would have been very easy estates to have dealt with if there was a will or the right kind of deed or the right kind of document turns into a year, 2 years worth of going through probate and finding heirs at law, because now we're looking at Texas statute to figure out who gets what. And it would have been far less time consuming and far less expensive just to have gotten it done in the first place. So that is one of those that I think is a lot of people stop because they don't feel like they can afford it now. trust me when I say your family's going to thank you if they don't have to expend all of the assets to fix it later. People don't want to talk to a stranger about their family or their money. If privacy is a concern for you, then come talk to an estate planning attorney, because there are things we can do to make sure that your estate remains private, right? If you don't want people knowing your business, you have to tell at least somebody, because if you don't do anything at all, then everybody's going to know everything at some point. We're all going to have to figure it out, and it's going to be that much harder on your family and that much harder on your estate to make those determinations, to figure out where you have stuff, how much is there, what it should be worth, who owns it, how they own it, etc. And finally, people don't want to think about their mortality. I think my favorite, when I'm sitting down with people for the first time and we start talking about their estate plan, and they start using the phrase, if I die. I hate to be the bearer of bad news. It's not if, it's when. Most likely you have quite a bit of time left, but you may not. This isn't a question of if, it's a question of when. And so having it all set out, having your plans laid out, having everything ready to go in case something happens, it's a kindness that you can do for your family. And it makes sure that you have some semblance of control over your things. Okay, so the planning documents everyone should have: a will and or a trust. So I know everyone has heard about a revocable living trust, or you may have heard about a trust. There are reasons to have them and reasons to not. I'm not going into that. That's beyond the scope of this particular presentation, because that's a whole hour all in itself. Should I have a will or should I have a trust? The important thing is that both wills and trusts take care of your property at death, right? So you need to have something that takes care of your property at death. You should have a durable power of attorney. As an elder law attorney, your durable power of attorney is more important than any other document on this list, hands down. If you die without a will, it's problematic and we have to spend a lot of money to fix it, but we can fix it. If you become incapacitated without a durable power of attorney, our only option is to go to court, have you deemed incapacitated, have a guardian placed over you, and then that guardian has to be under court supervision until the day you die, managing your affairs. It is a difficult process. We're not big fans of it in Texas. You have to show that there is no other possible way to manage the situation. One of the ways that we can show that the situation can be managed without a guardianship is with the durable power of attorney. And so it is absolutely crucial to have that. And it's really important to make sure that it has the right terms in it. Anyone can pull a Texas durable power of attorney offline and sign it and notarize it and be done with it. But if you don't know what you're initialing in terms of the powers that you're giving to somebody else, if you don't know that you need additional powers written in because of your circumstances, then you could end up with a document that simply does not do what it is that you need to have done with it. That happens so often in my practice. Adult children come to me and they have their durable power of attorney in hand for their elderly parents, and they're like, all right, I got it. I have the power of attorney. I can do whatever I need to do. Here's the power of attorney. Let's get this going. And I look at the power of attorney and I'm like, well, you're not authorized to do these things that you want to do, because the document doesn't say that you're authorized. It is not as simple as just saying this person can do whatever it is that they need to do on my behalf. We have statutes that undermine that statement. Even if it's in the durable power of attorney, that does not mean you can do whatever it is you want to do. There are limits, which is why it's important to talk to somebody when you're creating it, to make sure that it's got the powers there that you need. You need a medical power of attorney for someone to make medical decisions for you. Hipaa authorization to make sure that there's somebody who can gather information for you. Your living will or physician's directive. And I'm going to go over all of these documents again in detail as we go on. Designation of guardian prior to need, an appointment of agent for disposition of remains. We have a document from beginning to end in Texas, and they are worth sitting down, looking at and filling out and making sure that you have the right people in charge. Okay, So the two primary elements of your estate plan, your people and your things. That's it. That's as intimidating as it gets. We're talking about your people and your things. A will is nothing more than instructions for your people about how to handle your things. That's it. An estate is generally going to be land, financial accounts, a vehicle. If you happen to have some sort of collection that's been appraised and insured, all of that's going to be part of your estate. So when you're thinking about creating a will, the important things that you need to ask yourself is, what do I own? You'd be surprised how many people don't know exactly what it is that they own. Do they have mineral rights? Do they actually pass down? They know that somewhere in their family line, they were supposed to have gotten mineral rights, but did that ever actually happen? Were those deeds ever actually signed? What do they own? It's the first thing we have to figure out when we're dealing with your will. What do you have? Does anyone else own it with you? Is it community property? Is it separate property? This goes back to that house again. If your spouse passed, was their estate probated? Did you have some kind of process to make sure that their half of the house passed to you? Where do you want your property to go? How do you want it distributed? You have a couple of kids and you want it to go equally? Great. You don't have children and you're not quite sure where you want it to go? Do you want to go to charities? Do you want it to go to nieces and nephews? That's a great conversation to have with your estate planning or elder law attorney. Where should these things go, and what are your goals? Everything is always going to come down to, what are your goals? What do you want to accomplish with this plan? And then it's, who do you want to manage it all? So who's your executor going to be? A lot of people choose their spouse. If you don't have a spouse, they choose a sibling. Some people choose their parents. Keep in mind, anytime you choose somebody of your generation or older, they're aging with you, right? And so if you've chosen them, when it comes time to actually take care of your stuff, they might not be able to do so. So I always highly recommend looking at the younger generations as well for successor agents. Having successor agents is necessary to make sure that your will is managed the way that you want it to be. Okay, so giving your things to your people at death, nothing passes automatically. And I know that we kind of think about it as it does, like, oh no, my IRA is automatically going to pass to my spouse automatically. It doesn't. You had to go in when you started your job and you put in that beneficiary designation that said that you wanted your IRA to go to your spouse. It didn't pass automatically. You had to affirmatively do something to say who it's going to go to. That's the same thing with a will or a trust. You have to affirmatively say who your stuff's going to go to. Otherwise, it's going to pass by whatever the state of Texas says. And that's it. State law, generally speaking, there's going to be a distribution plan. If you didn't plan it yourself, the state that you're in has a plan for you. You may not like that plan. You have no option. If you don't do it yourself, the state will figure out where your stuff's going to go. Okay. There are the things that go to your people outside of a will. And it's really important to know which of these things are there. So a right of survivorship oftentimes happens on property. You can do it. You can fill out a right of survivorship for your motor vehicle. There are different kinds of bank accounts that you can have with a right of survivorship. It automatically passes to the other name on that account. Usually, again, when you have spouses, then the account is going to have a right of survivorship. But also on bank accounts, if an adult child gets on an account with their parent to help manage things, if they get on that account jointly, then it creates a right of survivorship. This can be problematic in two different situations. Well, it's generally problematic, but primarily it's problematic because when the parent dies, that entire account then belongs to that one child. If that one child wants to do right by their siblings and says, oh, I need to distribute this equally amongst my siblings, that was always the plan. Well, now they're giving money, they're giving something that belongs to them to their siblings, which means in a case that I dealt with in probate, the executor, who was the oldest brother, had the account, it went directly to him. There was about $400,000 in it. He then wanted to distribute to all of his siblings. Well, he has to file gift tax returns now because the gift tax return exemption amount is only $16,000. And each of his siblings was getting $100,000, right? And so even though he wanted to do the right thing, he still was somewhat punished for having his name on that with a right of survivorship. And then you have the other side where you have the sibling who's like, oh, this is mine, great, I'm going to keep it, and then not share it with anybody else, right? So that's the other thing that happens. So if you are on an account with an elderly parent or with your adult child, it's really important to know how that account is going to pass. Is there a right of survivorship on that account? All you have to do is call the bank and ask, they'll tell you. Beneficiary designations, they pass to the named beneficiary regardless of the will or trust. So if you started a job before you were married and you put your parents as your beneficiaries on your retirement account, and then you got married and you didn't change your beneficiary designations, your parents are your beneficiaries. It doesn't matter what your will says. Your will doesn't control anything with a beneficiary designation. So your life insurance policy, your IRAs, those kinds of accounts, if you don't have them named correctly, then they'll go to whoever it is that you do have them named for. Part of estate planning, part of this planning process is going through all of those documents and making sure that your beneficiary designations are set the way that you want them to be. You would be so surprised to know or to just hear how many times people just knew who their beneficiaries were. And then when they actually looked at the document designated their beneficiaries, it wasn't at all what they thought it was going to be. They just assumed they had taken care of it and they never did. And so that's part of this planning process, is going through those things as well. Okay, so what is a valid will in Texas? So first off, the person has to have capacity to create that will. So they have to have legal capacity, meaning they have to be over the age of 18. They also have to have testamentary capacity, which is being of sound mind. And there's several factors that are used to determine that. So they have to understand what they're doing, that they're creating a will, and what the effect that will have, meaning that they know that their stuff is going to pass to their people upon their death. And they have to know what they own. What does this will control? What assets am I passing? They have to know who their heirs are. And they have to be able to choose what they want and hold all of these thoughts together at the same time. If they are able to do that at the time that they're signing the document, then they have testamentary capacity. It seems like a relatively low bar, and it is, which is why it's important to understand that if you are caretaking for someone who the doctor has diagnosed with some form of dementia or some form of incapacity, that does not necessarily mean that they no longer have capacity to create a will. It's a different kind of assessment. There's capacity from a medical perspective is a spectrum. Capacity from a legal perspective is a light switch. Either you have it or you don't. And so just because someone is maybe in the early stages of some form of dementia, that does not mean that they cannot still take care of business. And again, that's something that you want to talk to an elder law attorney about. Have them talk to an elder law attorney and see if they can actually do some of this documentation if they haven't already gotten it. And it's important that the will cannot have been tampered with. Things that I've seen, people think that they should just be able to change things when they want to. You can't just change a will because something else has changed. Like you mark out a name and then you write a new name in for the executor and you initial it. That's not valid, right? I have seen other people who have retyped up parts of pages and then just put their new pages in. That doesn't work. Your will has to be executed with all of the ceremony, pomp, and circumstance required by statute. And if it is any changes you want to make, also have to be executed with the same pomp and circumstance required by statute. It's not so easy as to just go in and mark it out like it's a contract. A will is not a contract. We don't treat it the same way. All right, 2 ways to write a valid will. It can be typed, signed, attested by witnesses. The witnesses will be expected to testify in court that the will was created in the decedent, by the decedent, unless there's also something called a self-proving affidavit with it. The self-proving affidavit is something that will be supplied by the attorney when you draft it, and that keeps your witnesses from having to come to court and testify that they were there. Or the will can be entirely in your own handwriting, signed, no witnesses or notary needed. Technically, a post-it note on a house that says this house belongs to my son Bubba, signed Mama. If everybody knows who Bubba and Mama are, and we have witnesses attesting to the handwriting of Mama, that could technically be a will in Texas. I don't recommend trying to probate that. That is going to cause all kinds of issues and all kinds of problems. So if you're going to handwrite your own will, put it in some kind of form that's a little bit easier to do. Or better yet, don't handwrite your own will. Talk to an attorney, have them draft it for you. Get everything set up, make it easy on your family to probate your will, even if there's no challenges. A poorly done DIY will can cost your family money. Even if everyone gets along and there should be no issues for anything, if it's not done exactly right, then they have to jump through a lot of hoops. Your family would have to jump through a lot of hoops just to get that will probated. So I highly recommend actually seeing somebody about creating a will rather than trying to handwrite it and do it yourself. During COVID, we definitely were recommending some people do some handwritten wills because you couldn't have witnesses come to your house. It was much harder to get things done. But now that we're coming back out of it and we can actually be in presence of other people again, I highly recommend if you did do a handwritten will during the pandemic time, I highly recommend going back and having it done fully and professionally, have it reviewed, make sure that it does what you want it to do. All right. Oh, here we go. Why shouldn't I just create my own will? I always get ahead of myself in these. It's easy to create problems and time and money for your heirs when you create your own will. Even if you think you've managed everything, if you don't know what goes in a will, then it's harder to deal with. It's harder to know for sure that you got everything that needs to be there. Examples of issues that arise with DIY wills, and it's not just the wills, it's the DIY estate plan generally. Minors unable to access their inheritance. That was a client of mine who received an inheritance from his grandfather when he was like 14. It went into a Uniform Minors to Trust Act trust for him for his benefit. He wasn't supposed to get it until he was 18. However, the terms of the UTMA, the Uniform Transfer to Minors Act trust that was used, didn't include a successor custodian. And so the bank wouldn't release it. He was 24 by the time he came to me and was like, I don't know what to do anymore. And the statute didn't cover that circumstance. So I had to work it out with the court as far as what's going to be the best process to get an order signed to get to the bank to release the funds. All of that could have been avoided if the estate plan had been properly written and reviewed. Making heirs lose government benefits. I do special needs planning. I do planning for Medicaid, people with benefits, people on SSI, and it's very, very easy for a well-meaning person who is not necessarily paying attention to their to what they're doing to leave money to somebody who's on government benefits. Again, this is something that I just dealt with. A gentleman on Medicaid benefits, home health care, he needed all of them. Received a $10,000 life insurance policy. That was a problem because that could have kicked him off all of his healthcare benefits. And so it is critical when you're drafting these, or when you go to an attorney, or when you're writing, that you know whether there's somebody who's even tangentially related to you that could potentially lose benefits. I was speaking to a couple 2 days ago, and during the course of our conversation, I learned that the woman's sister had Down syndrome and her mother was on SSI. And I was like, oh, okay, we need to plan for that. We need to make sure that if there is any reason at all why your estate might go to them, that it goes to them in such a way that it won't jeopardize their benefits. There are things that we can do. And a lot of people, one of the reasons why you go to an attorney is because a lot of people don't know what they don't know. They don't know all the considerations that have to go into this to make sure that their family is going to be protected. People trying to give away money that wasn't technically theirs, though they didn't realize it, right? So they have an account set up and it has income going into it and they're married and all that income is community property, but because the account's in their own name separate, they're like, oh, this is my money. But they don't have a marriage agreement, they just have a separate bank account. Having a separate bank account does not make it separate property, just FYI. So knowing again what you own and how you own it. And then if you have no living witnesses to testify to handwriting, that's becoming harder and harder. We don't handwrite stuff anymore. We don't do a lot of handwriting. People don't write checks anymore. You might have cards. That's really kind of what we rely on now. It's like, yes, I got Christmas cards. People don't write letters anymore. So being able to testify to handwriting becomes a lot harder, especially if we're looking at extended family. If you don't have immediate grandchildren to be able to testify, because technically it cannot be an interested party. So it couldn't be any of the kids if they are going to be beneficiaries under the will. It has to be somebody else who recognizes the handwriting. That is becoming an issue. So should your will include a trust? So we talked earlier about having a will or a trust. You can have a will and a trust, right? So you can have a will that creates trust. So if you have a minor child, your will needs to create a trust for that minor child to hold their assets until whatever age you want them to have it. If you want to leave property to somebody with a disability or somebody who collects government benefits, you want to leave it to them in a trust. And you can create a trust inside of a will to do that. If you want to leave property to a person with special needs, or if you want to tie strings that go beyond just who gets the inheritance, then you'll need to put that in a trust. Generally speaking, a will gives things outright to people. If you want to say you get this when you graduate college, then that's a trust, right? If you're putting strings attached, then you have to do that with another vehicle. And do you want to leave funds to support a pet? There are things called pet trusts where you can actually like put something together so that whoever is going to take your pet and be taking care of your pet also has some funds so that it's not so onerous on them to do that. All right, this is my last bit on the wills because everyone's like, so what is probate anyway? The probate process, it's just a matter of wrapping up the estate. A will is just a piece of paper until a judge says otherwise. That's it. It does not matter. People come to me all the time and they're like, oh, well, the will names me executor. It's like, yes, but is the person still alive? Well, yes, then you're not the executor. You're not the executor until that person has passed and the will has gone through probate and the judge has said, yes, you're the executor. So a will document itself has no effect at all whatsoever until a judge agrees that it has been executed with all the pomp and circumstances required by statute and has deemed it a will. So that is what a will is. Until it's probated, a will is paper. So carrying out the will, the executor, the person you named, is the one that applies to the court. They hire the probate attorney. The court checks that the will was created correctly, and then they validate the will, and then the executor does their job. That is it. That is probate process in a nutshell. Is it ever that simple? Very rarely, but sometimes. Sometimes we get it exactly right, and those are the best. It also confirms ownership of things, like who's going to be getting property, and it prevents unscrupulous credit scams. You'd be surprised how many people get random notices of debt after someone's died, and there's no record of that anywhere except for this bill. And a lot of people just start paying bills immediately as they come in because they feel this moral obligation to do so. My advice is always, let's validate those bills first, because there are absolutely scammers out there who are trying to take advantage of your grief. And so we need to make sure that these bills coming in are accurate, and they are actually debt of the decedent. So that's a whole other presentation as well, just on the probate process and best practices. All right, so that was the will. How the will's done, what it's for, and why it's important to do it right? So now let's talk about your power of attorney. You choose someone to make financial decisions for you when you're unable to. If you are declining in any way, if you are incapacitated in any way, physically, mentally, it is really important that you have somebody that you trust who is going to treat your money not like their own, right? Who's going to treat your money like yours, and who's going to use it for your best interest, and who's going to do the things that you need to have done with it. Choosing agents under the power of attorney, under all of the next documents, choosing agents, these are the people who take care of things while you're alive. So it's really important that you choose people who are going to do right by you. This is not a popularity contest. This is not about choosing the oldest to do it first, to go first. This is about choosing the right person for the job. If one of your kids is really on top of it and they have everything organized and they know how to keep a spreadsheet, that's a great one. If one of your kids is constantly in fear of bankruptcy, maybe they're not the person to put in charge of your money. If you don't have people, that is something to talk to an attorney about. We have to talk about what kind of alternatives there might be. Are there friends? Are there nieces, nephews, etc.? One of the most difficult problems that we have to solve in elder law is the idea of elder orphans. People who they're no longer married, they don't have children, they don't necessarily have family close by that they can rely on to help take care of their stuff. And so who can they choose? What are their options? Sometimes if the estate's large enough, we go straight to a living trust so that a corporate fiduciary, a corporate trustee is there to help manage that money. Sometimes we look to professional the professional fiduciaries, people who will agree to professionally manage your money under a power of attorney. They're fewer and far between, but we do have some. But we have to talk this out. Like, this is a discussion that you need to have if that is a situation that you're in or somebody that you know and love. A well-drafted power of attorney may alleviate the need for guardianship. I can't stress that enough. A guardianship is an expensive process where the court names someone to handle your affairs. And then you're under court purview for the rest of your life, and your guardian is constantly having to go back to the court for everything. And I mean everything. You get an allowance, your guardian will get an allowance for your monthly expenses, but if anything comes up, they have to go back to the court to say, hey, can I have more money for this? And it can be a slow process, it can be an expensive process, and it can be a full-time job. So we want to avoid that at all costs. Have a power of attorney ready to go. All right, medical power of attorney. I don't know where I'm at on time. Okay, at about 12:40, so I got about 20 minutes until we can do some question and answers because I have about an hour and a half today. Medical powers of attorney. Choose someone to make medical decisions for you when you're not able to. This isn't so much a best interest standard because generally speaking, a medical professional is not going to bring options where one of them is not necessarily in your best interest. You want somebody who's going to choose the option that you would choose if you were there. And so, or if you were able to choose it for yourself. And that's why it's really important that the person that you name under your medical power of attorney is someone that you know, someone that you trust, someone that knows you, that you've had these conversations with, that you've talked to about your medical care and what you want. There's a whole world between being competent and like running your life and being in a situation where someone needs to pull the plug, right? There's a whole world of medical decisions that can happen between that. The agent under the medical power of attorney is not just the person that would be responsible for deciding whether or not your artificial life support is necessary or required at the time. There are other decisions. And so talking to your family, talking to your agents about how you want to be treated, how you want to have your medical managed. If you are in a situation where someone else is doing that, that's really important. Texas does not recognize the 5 wishes document. I love it. It's online. You can go, it's a series of questions, because again, this is one of those things where you don't know what you don't know. And I can't even tell you what sort of questions you would need to be able to talk to somebody about in terms of your medical decisions. But the 5 wishes document kind of goes through a whole bunch of different scenarios and gives you an opportunity to think about them and decide, what I want in this or in that circumstance. Like I said, it's not binding in Texas, so your agent can't bring it to a doctor and say, well, here you go, this is what they want. But it could serve as guidance to your agents so that they're not struggling. And also can serve as a conversation starter. Sometimes you just need to know how to start the conversation, because this is not an easy conversation to have. Just trying to figure out, what do you want for your medical care? Again, if you don't have an agent, Texas law determines who can make those decisions for you. There's a statutory list, starting with family, your spouse, your children, parents if you don't have spouse or children or they're not adults. And then again, make sure your agent knows your wishes. I believe that I don't know if it's the Alzheimer's Association, or there's a couple of associations out there that kind of go over advanced directives and the best ways to have these conversations. There's even a card game that you can buy that's like where a bunch of situations come up and you say what you would want to do in those situations. Like, they're trying to make it as easy as possible for people to have the conversations. They're hard conversations. And so I recommend going and finding some of these that might work for you and your family. Hipaa authorizations, these are going to be your eyes and ears. This is not a decision-making document, but it does allow people to communicate with your healthcare providers about what's going on with you. It's one of those situations where you may want somebody else to be with you in helping manage your healthcare, to be able to call up the doctor's office and say, hey, my loved one is having this bad reaction to this medication. Do we, what are our alternatives, right? You need the doctor to be able to talk to your helpers. Like I said, your helpers can't necessarily make decisions, but they can at least get information. And it gives the doctor ability to give information. All right, designation of guardian prior to need. If you have to have a guardian, if the power of attorney is not strong enough for whatever reason, most likely in cases of exploitation and financial elder abuse, right? If your durable power of attorney is not sufficient and we have to go to court, you can tell the court who you want to be your guardian. And more important, you can tell the court who you don't want to be your guardian. I did not realize how popular an option excluding people from guardianship was going to be until I started doing this document. And then it's like, everyone's like, oh, well, I don't ever want my sister to be in charge of my stuff. Okay, great. Then we will put that down 100%. You need to be in control of as many things as possible. And sometimes that includes making sure that the people that you don't trust don't become in charge of your stuff. All right, your living will physician's directive. People call it a living will. I find it very confusing because they confuse it with an actual will. So the living will physician's directive is a very, very simple document where you get to make the decision while you still sound mind whether or not you want artificial life support in very limited circumstances. If you are not able to let your wishes known, and the prognosis is that you are not expected to live longer than 6 months, no matter what medical interventions they give you, you can say, keep me comfortable and let me go, or keep me alive as long as possible. The other condition is if you are considered incurable, meaning that they have already done everything that they possibly can for you, and you're not getting better, and they don't anticipate that you're ever going to get better. You can say, keep me comfortable and let me go in that circumstance, or keep me alive as long as possible. This is instructions for your doctor about what is important to you, about how you want to be treated. I've had some younger clients who are like, I don't know. And I'm like, okay, that's fine. You don't necessarily have to have this document. You don't have to fill it out, but it is incredibly helpful for your families to know where your thoughts are, where your feelings are on this particular matter. And like I said, it's a very limited circumstance. During COVID, I had a lot of people be like, well, what if I want to be on the ventilator? What if I get COVID and I have to be on a ventilator? Well, then you're neither terminal nor incurable, right? So this document wouldn't apply because the doctors think that the ventilator is going to make you better. So we don't need to worry about the physician's directive in terms of having you not put on a ventilator in those circumstances. All right, finally, we have the appointment of agent for disposition of remains. We've got a document for everything in Texas. This one comes in very, very handy in blended family situations where a second or third spouse may have a differing opinion from the children from a previous relationship. It's very important to say who is going to be in charge of arranging and planning and paying for your funeral, if you don't already have it done. You can also put your special instructions there. If you have specific music that you want, you can attach it. If you have specific place where you want to be buried, you know where you have a plot already purchased, you can put all that information there. I highly recommend pre-planning. I'm a big fan of taking care of as much stuff as you can when you have the ability to do so. Pre-planning it's a contract. It's like an insurance contract that you can go to any funeral home, you sit down, you tell them what you want, they tell you how much it's going to be, you buy the insurance contract, and then when it's time, your family calls a number and gives a policy, and most of everything is just taken care of. They show up for the services. It's a kindness, right? The two most kind things you can do for your family: plan for your funeral and plan for your long-term care. 100%, the kindest things you can do. We can always manage it if you don't, but it's a good idea. All right, so what happens when you don't plan? You lose your ability to make any decisions regarding your property, your legacy, your life during incapacity. You simply have given that up. You don't get to make any decisions anymore. Probate can be longer or more expensive when there's not a will or trust, or when there is a will that is not properly created. There may be pitfalls you never knew that the planning would have highlighted, such as that right of survivorship in the case where you have one child amongst several siblings that automatically inherits this account and then either keeps it for themselves, much to the dismay of the other siblings, or wants to distribute it equally amongst the other siblings and ends up having to pay an accountant additional funds to make sure that they don't get in trouble later on for this gift they're giving, right? Understanding these kinds of pitfalls are very important. And your property could be distributed per state statute, whether you want that or not. All right, so that is I feel like I'm out of breath at this point. So this is my information. I am in Houston. This is my name. I'm going to stop sharing my screen, and then we can go ahead and start answering questions if people have questions about what we're doing or anything that I had to say.
Well, this was great. This is awesome.
I have a question. I have a sister who has a neighbor who stated that her mother executed guardianship prior to really needing it. And so my sister wants to do the same thing for my mother. My mother's showing signs of dementia. She hasn't been formally diagnosed, but I keep telling her guardianship is something that's really expensive, and I don't know if that's something we want to pursue. Is it less expensive prior to the need, or?
So you don't seek a guardianship prior to need. Guardianships are very strict. We're very strict in Texas about what constitutes guardianship. Somebody asked for my information again. That's why I put it back up there for y'all to look at. A guardianship in Texas, when you go to court, the individual already has to be incapacitated. If somebody wants to name the person that they want to manage their stuff while they are still have capacity, that is exactly what the durable power of attorney does. Like, that's the whole point of it. That's what the medical power of attorney does. That's the whole point of it. A judge is not going to strip the rights away from a competent person. It is a last case scenario. As a matter of fact,
Yeah.
I have actually been in circumstances where somebody has sought a guardianship over individuals who still were somewhat competent, but the person seeking the guardianship didn't agree with their decisions. And the court was very clear, they have competency. We can't have a guardianship. And he looked at the couple that the guardianship was being sought over and was like, you need to get your powers of attorney done right now, because you need someone to help you, but you're not incompetent, but you do need assistance. And so that is the key.
Yeah, and that's what I thought. And I kept telling her that, that and the fact that my mother's still driving. And I said, if you get guardianship, if you want to try to pursue this, and she gets into a really bad accident and it's her fault, you are liable, from my understanding. So
guardian is not, so first off, if she's still driving and she's competent to drive, then she does not qualify for a guardianship. A guardian is not liable for the actions of their ward, because you can't sit on them, you can't lock them up, you can't force their medications down their throat. Like, a guardian has limits to what they're allowed to do. And so you're not necessarily going to be held liable for somebody else's stuff if they get into a car accident. But that person, if they're in a guardianship, then they no longer have a drive. They should no longer have the keys. Like, the guardian's responsibility is definitely to take those keys away, and to manage that vehicle in whatever way. And so one of the things that taking the keys away is hard, but that is not as far as like your mom's concerned, I would just be very clear with her that a guardianship strips your rights. You are reduced to the legal status of a minor child.
right.
Meaning you don't get to choose where you live. You don't get to have a checkbook. You don't get to write checks, buy groceries. You don't get to do anything because somebody else has been put over you in that.
Okay. Thank you for clearing that up. I'll be sure to pass that on to her.
You're welcome. Very strong feelings about guardianship. They're necessary when they're necessary, but when they're not, man, let's avoid them at all costs.
Right. And I have a child with a disability. And so I was familiar with guardianship many years ago because of that situation. And we were told at that point, courts aren't likely to grant them. And, trying to pursue one is a big responsibility because they're pretty much irrevocable once they're granted.
It's hard. It's very hard to get someone out of a guardianship. You can, it's possible, anything's possible,
Right.
but it's expensive. That is 100% true. Pursuing a guardianship is expensive.
Okay, thank you.
You're welcome.
Hi, this is Vijay Kane. A couple of points. I'm a financial advisor, and I'm so glad you brought up the issue of beneficiaries. I just wanted to share a small story. I had a client who passed away recently, and she was up in her 80s. And so she had designated her niece as the beneficiary on her IRA applications and non-qualified annuity applications. And she talked to me about getting the name changed a couple of times. And so I said, I'm going to get, I said, she's in West Texas. I'm here in the Houston area. So I got the paperwork sent over to her. And before she finished the paperwork, she passed away. And she actually called me. And so I always stress to all of my clients, check your beneficiaries. Another interesting point that you brought up, a lot of single folks will have their parents designated as beneficiaries, and then eventually they get married. And the financial institution does not have to listen to anything else. Whatever is on their paperwork is all that counts. And so I'm really glad you brought that up. A couple of other questions. You mentioned about the 5 wishes document is not valid in Texas. So is there an addendum to that 5 wishes? Because there are some nonprofit organizations here that are actually making presentations on this. And I've always had that question to get this thing checked out from someone like you to see how the state of Texas feels about it.
So if you've named your agents under the medical power of attorney within your 5 wishes document and you signed it and notarized it, it does not meet the statutory requirements of a duly executed medical power of attorney. What that means is everything that you've written down, signed and notarized are suggestions. A doctor does not necessarily have to, as a matter of fact, a doctor shouldn't take your agents at their word with that document. So if you filled it out, you also need to create and execute a medical power of attorney, a Texas form document medical power of attorney to actually be able to name your agents. And then make sure your agents have that 5 wishes document. Like I said, I love it, but it is not binding in Texas. And so if you want your agents to know the information that you put in that document, give it to them, absolutely, but you cannot rely on it. And the doctors don't have to don't have to honor it, right? It gives your agents kind of ammunition to like go toe to toe and argue for you, but it's not something that is going to be legally binding. And have a separate medical power of attorney to name your agents, because if you've named them in that 5 wishes document, it does not count.
You think of these online resources for creating wills. Are they able to do it as well as you would do it, or one of, you know? So
there's I have a couple of thoughts on that. First off, they're not state specific. And so it often happens where somebody will bring me a will that they've done online, and it doesn't have language that we require to make things go smoothly. Doesn't mean I can't probate it. I can. It just means that the executor has to jump through more hoops than they would otherwise have had to jump through, right? Also, a lot of problems come again when someone's doing it themselves and they haven't thought through, because they don't know all of the issues regarding their estate. And so they put a bunch of stuff down and they think it's going to do for them what they want it to do, but it doesn't actually do for them what they want it to do. And it comes as a great surprise to their beneficiaries to find out that everything mom and dad said about how their stuff was going to be distributed, turns out that's not what they actually wrote in their DIY document, because they didn't understand what they were doing. If you have the simplest of situations, a single person, 2 children, everything getting split between the 2 children, you're not trying to add stuff, you don't know anything else, In that case, sometimes, sure, it might work fine. You might have been better off not doing that, instead doing a transfer on death deed in a small estates affidavit, right? There might have been other options, but that's the only situation in which I've ever seen it work. I have seen so many DIY wills, and it costs and online wills, and it costs their family 3 or 4 times what it would have if they had just done the will with a Texas attorney. And so I know they like to advertise it being perfectly legal in all states. And you know what? It is legal. It's not legal. It's just not efficient. And it doesn't necessarily do what you want it to do, both because they don't have the right language for every state, and because the individual doesn't always know how they're answering those questions and what the questions are asking them really mean in practice.
I got a whole bunch more questions for you, but I'll approach you privately about that. I wish we can work together since I'm a financial advisor and have a whole bunch of clients that can use your help. So I'll let other folks ask questions. Thanks.
And there's a question in the chat, Angela, about the cost. I know you just kind of talked about online, like using tools online, but there's a question in the chat that says, what is the cost or fee to prepare a will or trust? I know it kind of depends, but if you have a range.
Yeah, no, that definitely does depend. The costs of wills and trusts are different, because a will, the administration and the time and effort that it takes to deal with a will happens on the back end. Right, so the money going to be expended is going to be expended in probate to manage and administer that will. Creating a will is much less expensive. Creating a trust requires all of the administration to happen now, so that when the person dies, there is no probate. So we're passing outside of probate. And it's just a matter of seamlessly having a trustee come in, be able to manage the situation and administer the trust from there. So a trust is always going to be more expensive than a will is. It depends on where you're at and what all you need. Because if you just, like I said, if it's a very simple situation, then it's going to be less expensive. If you have a child with special needs who's going to need a special needs trust that we're going to have to set up and manage for them, that's going to be a lot more. If you have really big retirement accounts, and with the Secure Act and the 10-year distribution now, except for minors, and I can't even begin to talk about that because I'm still wrapping my brain around it, then that again is going to make it a different scenario. So if you're interested in what my office does, I don't want to speak for anybody else. And so I can't tell you what a general cost is going to be, because everyone is different. If you are interested to know how my office does it, you are welcome to call. You can talk to my office manager, Evan, and he will walk you through the process, and he'll walk you through generally how we do our pricing. I do flat fee for my estate plans when if it's not something crazy, which I rarely do hourly for estate plans. It's almost always flat fee. So I know that was not the answer that you wanted, but it was the very, very much the lawyer answer. It depends answer.
Thank you. There are a couple more that came through the chat. There was one about, and I'm just reading them just to be fair, because they came in a couple minutes ago.
Sure.
Let's see. Can a medical power of attorney be used for individuals who are not a U.S. citizen, or does citizenship even matter with medical power of attorney?
So medical power of attorney is for the doctor to know the person that they are going to be dealing with when making medical decisions. I've not seen anything that leads me to believe that a non-citizen should not have a medical power of attorney, because someone still has to make those decisions. It does not like create any kind of it doesn't create any kind of situation other than the doctor knowing who to talk to and who can make those decisions. And so I would still absolutely have a medical power of attorney, even if you do not have citizenship status. Somebody's asking about original versus copies. I'm so glad you asked that question. Copies are fine for all of the fiduciary documents. You want to keep your original will. You want to keep the safe. You want to keep your will original and safe. I can probate a copy, but it's, again, hoops. Why you don't want to jump through hoops. So keep your original. All the rest of the documents we talked about, your durable power of attorney, medical power of attorney, Hipaa authorization, all of those, a copy will suffice. Have your originals, scan them, send them to all of your agents, make sure all of your agents actually have copies of all of them. As a matter of fact, what I advise all of my clients to do, and I will advise all of you to do this as well, when you get your medical power of attorney and your Hipaa authorization executed, make copies of them, fold them up, put them in an envelope labeled medical power of attorney and put it in your glove box. That way you have it there if you end up at the hospital at 4 o'clock in the morning, and you have it there if you're ever in a car wreck. The EMTs can just easily go and see that you have a medical power of attorney right there. Fantastic. It'll have phone numbers on it and people who we need to contact to say, this is what's happening. You do need to have a separate Hipaa authorization. In Texas, we do not have a combination medical power of attorney Hipaa. They are separate documents. Can you update a medical power of attorney from another state to Texas? If you're the originally appointed agent, you can't do anything if you can't change the document at all if you're the agent. Only the principal can change the document. So if your principal is incapacitated and they have a medical power of attorney from New Jersey, generally speaking, it's going to be honored because we don't have another option, or the doctors are going to look to Texas statute. Again, like I said, it's going to be spouse. In practice versus legal is a whole different ball of wax at the hospital, right? The doctor just wants somebody to make decisions. It only comes into play when we have people who are arguing over who gets the right to make decisions. That's when we really have to go look at those documents. I've been in hospital situations many, many times, and one of the things that has always struck me as kind of funny is if you are in the room with somebody and you are of an opposite gender and you look maybe around the same age, they will assume you're the spouse and they will just start asking you questions, whether you are or not. That's how it is in practice, right? And so there's the understanding, you know, how effective are these documents in terms of like putting your wishes down versus just naming somebody to make decisions. That's kind of the issue. But the original question, no documents, an agent cannot change a document if the principal is incapacitated. Only the principal is ever allowed to change their documents. My parents' will was written and executed in Louisiana. They have rental property here, but have moved 2 years ago to Houston. Do I need to do anything to make sure all is good here? Yes. They still have rental property there. And now you're in Houston. Yes, you definitely need to take care of that because now you're in a situation where you have property in 2 states and probate is state specific, meaning that if they die in Texas, you're going to probate in Texas, and then you're going to hire an attorney in Louisiana and probate their estate in Louisiana. We can avoid that. So let's avoid that. So talk to somebody about getting their estate planning done here, understanding that they have property in another state that they want to avoid probate on. Does wording matter? Sorry.
Oh, sorry. I wanted to piggyback on that question. My mother actually lives here, but all of her property is in Louisiana. So do we have to probate here?
So if she dies here and her residence is here, I don't know Louisiana law. Here's the question that I can't answer for you. You can absolutely probate in Texas. Whether or not you can probate in Louisiana, I can't answer. That's going to be determined by Louisiana law in terms of how they manage jurisdiction for probates. Now, if Louisiana will allow you to probate something in Louisiana simply because there's property there, but it's not their homestead and they don't have residency there, then sure, but that is a question for a Louisiana attorney. I can tell you that if she lives and dies in Texas, you can probate in Texas. Texas will have jurisdiction. I cannot tell you whether or not you can probate in Louisiana instead. That's a topic for a Louisiana attorney. Which is why I really like, if you have property in other states, I really like trusts to put all the property in one spot, pass outside of probate in all of the states, and all be managed by one trustee. Huge fan of that. I don't write a whole bunch of trusts because I think in Texas, probate for the most part is cheap, easy, and fast, especially in Harris County. But there are some circumstances where trust is absolutely going to be a better option, and property outside of the state is one of those. So somebody had a question about the difference between special needs trust versus supplemental needs trust. Does that language matter? Yes and no. The terms are the most important, but if you're dealing with the Social Security office in an SSI situation, and you have a trust called a special needs trust, they are going to be looking for provisions for a first person settled special needs trust, meaning they're looking for Medicaid payback provisions. They are looking for limitations on distributions. They're looking for very specific language if it's called a special needs trust. If it is a third person settled special needs trust, then calling it a supplemental needs trust means that the Social Security office is not looking so critically for specific language. I literally just did an hour on the differences between special needs trusts, the types of special needs trusts for a caregiving group for parents with kids with special needs. So that's a little outside the scope. In terms of whether it matters, it depends on what you're trying to set up. So we're going back to the it depends and what are your goals as to whether that matters. At what point do you need to establish a special needs trust for a spouse with Alzheimer's? Call my office. Because there's so many questions. I see that, and I have about 15 minutes worth of questions we need to go through before I can answer whether or not we can even do that, much less at what point. I think anybody who's 55, 60, if we have an issue with long-term care, meaning you don't have long-term care insurance, you're not going to be able to self-fund your long-term care. Let's talk about setting up spousal special needs trusts within your wills so that each spouse can protect at least half of the estate, right? It's a difficult thing to do. We have to manage it exactly right, but if we can do it, it can save so much in the end. If somebody is already incapacitated and the durable power of attorney doesn't allow you to set up a trust for them, then we may not have an option to set up a special needs trust. So the facts matter. Special needs planning, the facts are everything. Where's the money coming from? Who held it last? Who holds it now? Who's it supposed to benefit? Every single one of those things matter when it comes to special needs planning. And if you do it wrong, it could be catastrophic. So answering those questions are not, like, that's just not something that I'm comfortable doing in this sort of forum, but I'm happy to talk to you about it. I'm happy to talk to you about it. Call and make an appointment to have a few minutes with me and we'll talk about it. Parents moved from California to Texas. They have a will, a trust, durable power of attorney, medical power of attorney that was drafted in California. Do we need to recreate the documents in Texas? I definitely recommend recreating the durable power of attorney and the medical power of attorney in Texas. The California trust, the most important thing about the California trust is that California trusts, in my experience, do not have, let me back up for a second. Trusts in Texas require this homestead language to be put into it so that you can keep your homestead exemption. Trusts coming from out of state often do not have that language that allow you to put your home into the trust and maintain your homestead exemption with the county tax authority. So whether or not you need to recreate the documents, I don't know. Is it something that maybe we can amend to make sure that it's falling under Texas law? Maybe, right? So this is, again, one of those it depends questions. If we can keep the questions general, that would be more helpful. Each individual circumstance is always going to end with an it depends, and it's going to be a very unsatisfying answer for you, and I apologize for that. But that's the best that I can do without having so much more information. Do I advise families on the right pathway and steps to qualify for Medicare benefits for Alzheimer's down the road? Okay. The next two talks that I'm giving next Thursday and the Thursday after that are all about this question. 100% about this question. Like, what is the pathway? How do we get there? What's the best things to do? And I think the most important part about this question, and this is what everybody gets wrong, even it does not matter, attorneys who do not practice in elder law get this wrong all the time. Medicare is a healthcare benefit like Blue Cross Blue Shield, right? It's just health insurance. Medicaid is a long-term care benefit that you receive when you do not have sufficient assets to cover your long-term care in a skilled nursing facility. So that is, so we're gonna, when we talk about this, it's really important that we make sure we're using the right language, because there's no such thing as Medicare estate recovery. Everyone's entitled to Medicare at the age of 65. There's no estate recovery, right? Medicaid has estate recovery, which there are any number of ways that we can avoid estate recovery. Again, things we're going to be talking about in the next 2 weeks. So if you are interested in that question, come back and see me next week and the week after. Oh, good. Well, somebody liked an answer. I have a document that's a combined medical power of attorney and Hipaa release. And they just said they were separate documents. Is the combo valid? Again, it's about whether or not someone's going to honor it. Is it valid? No, I don't think you're allowed to have the combo medical power of attorney and Hipaa authorization in Texas. They don't have a statute saying that that's something that can be combined together. Is a doctor going to read your combo and be like, oh, look at that, I have Hipaa authorization, I can talk to you? Maybe they will, right? These documents are so very in the moment specific to the person who's reviewing them. And they are very rarely litigated. Like, if a doctor were to honor that Hipaa authorization and give you information, and then the principal gets upset about it and wants to sue the doctor, HIPAA is not a private right of action. So, I mean, it's so much more complicated and simple than is it legal, right? Is it honored? I don't know. I would do them separately. That's what I would do. Just make it easy, clarify it all. Don't risk it. Don't take the risk, just separate them. Can we get access to today's presentation as well as the next 2 weeks? Yes, I will make sure that Ariel has all of the slides in a handout presentation, and we did record it. Matter of fact, we're still recording. So we're recording all the answers to my question, to the questions that are coming in as well. I don't know of the recording when it all gets ready to go, what all is going to be on it. All right. Oh, there's another question. How do we get access? Oh, how do we get access to my talks on Medicaid next week? Register. Come back. See me.
Yeah, if you register for this one, you'll get you register for each week. So you'll get all of the emails. So if you received anything for today or from yesterday, then you'll get all of the reminder emails as well as the recordings. So we got you covered. As long as we have a valid email address, you'll get the information.
So talk about a little bit about next week and then the week after. So the next two talks are specifically on Medicaid, long-term care, qualification, that kind of thing. So next week, we're talking about pre-planning. What can you do? What are some options that we can talk about, and what's really important to have in place document-wise in order to pre-plan for long-term care? And when I talk about long-term care, I mean pre-plan for your long-term care, not just Medicaid qualification, though that is a part of it, but also what else can we do to use what resources are available. I'm a big fan of long-term care insurance, and we're going to talk about that. I would love the Jay's comments on that at some point in time, because I go toe-to-toe with financial advisors all the time about long-term care insurance and private pay. But it's important to kind of think about the best things to do setting up. And then the final presentation the following week is on crisis planning, which basically means something drastic has happened. Your loved one is in the hospital. They're about to go into rehab. They've got their 20 days under Medicare. They may or may not have a supplement, and then they have to go into a skilled nursing facility. And what do we do? So that is going to be the last presentation in this series. If my parents set up a living trust in their name and I'm the executor, the money that is in this type of will trust, am I the survivorship person? Okay. An executor is the person that manages the will. A trustee is the person that manages the trust. Beneficiaries are the people who get the money. So being named executor does not mean you are entitled to anything by virtue of being named executor. Being named trustee does not mean that you are entitled to anything by virtue of being named trustee. You must be named beneficiary to have a beneficial interest, if you will. So a trust is three parts: the person with the money, the person managing the money, and the person who gets the benefit of the money. That's it. That's what a trust is. And it's a document that is just the rules of how that's supposed to be done. And so when you have a trust is in effect, a living trust is in effect right now. A will, as I said, is not in effect until someone dies and it goes through probate. So an executor is not named until someone has died and goes through probate. A trustee is the trustee when they meet the terms of the trust to become the trustee, whatever those terms are. There could be any number of them, but that's what it is. I am the beneficiary along with my niece and nephew. Okay, then you are a beneficiary, but you don't get to use their living trust. There's so much more. Most likely their living trust, they are the current beneficiaries. And you are a residual beneficiary, meaning that you get it after they die, but not before, right? Unless the terms say otherwise. The thing about a trust, the big difference between a trust and a will, like I said, a will is not a contract, a trust is. And so a trust is just simply going to be, what are the terms? And that's what you follow. What are the terms, and technically what are the state's requirements for, what are the duties of a trustee under the state's requirements, depending on the state where it was written. I can speak to the requirements of a trustee in Texas. I cannot speak to the requirements of a trustee in California or in Ohio or in Louisiana or in New Jersey or anywhere else, because I'm not familiar with their statutes. Estate planning is a state issue. And so if you need to have a trust reviewed for your parents to find out what your duties are as the trustee, go back to the state where that trust was created to find out what those trust terms are. Don't go to a Texas attorney for an Ohio estate. Don't go to a California attorney for a Texas estate, right? Go where it is in the actual document.
I also wanted to add to that, because I did see a lot of, or not a lot, but some of the registrations, you might not be in Texas. That is the case for Medicaid as well. So next week, when Angela is speaking about Medicaid, she's speaking about it in Texas. So every state is different for Medicaid. Yes. So I did want to just put that out there as well.
That is 100% true. If you've seen one Medicaid plan in one state, you've seen one state's Medicaid plan. All of them are different. All of them have different benefits. And I want to be very clear here. When I say the word Medicaid, there are oodles of Medicaid programs in Texas. So if you have a neighbor who's on Medicaid, it may not be long-term care Medicaid. So you cannot compare your situation with theirs and say, well, they get Medicaid. Why can't I have Medicaid? Well, I don't know what kind of Medicaid they have. I don't know what sort of benefits. I don't know why they have it. And so when I'm talking about Medicaid in the context of elder law, I am talking about Medicaid long-term care benefits for Texas residents. Let's be very specific. I'm not talking about general Medicaid for people who have low income disabilities. Like, I'm not talking about SSI Medicaid. I'm just talking about Medicaid for long-term care. And so that's so the next two, that's what the focus is going to be. And I thank you, Ariel, for clarifying that. This is not going to work in another state. If you are calling from another state for a loved one who is in another state, or if you're watching from another state for a loved one who's in another state, contact an elder law attorney in your state for the best options for long-term care. The National Academy of Elder Law Attorneys has a list of their members. It's naela.org. Go there, put in a zip code of your loved one, and find a list of attorneys to call and talk about what the program is. If you are looking to move a loved one from outside of the state to Texas, my first recommendation is to see what benefits are available in that state before moving to Texas, because there might be benefits available in another state that Texas doesn't have, and maybe it's a better option to stay there. I don't know, but you want to get all the information as opposed to just jumping to Texas. If you have a loved one who's already on a Medicaid program in another state, there is no such thing as transfer. You don't transfer Medicaid from one state to another state. You start over in Texas. And if your loved one is receiving a benefit in their home state that we don't have here in Texas, there's nothing, like I can't do anything about that. So again, it might be in your loved one's best interest to stay where they are. I don't know. There's so many, Ariel said Medicaid is like a puzzle, and it is, and there are so many moving parts. And good, that goals, right? It comes back to the goals. What are we trying to do? What are we trying to accomplish? Is Texas the best place to accomplish it? Is another place the best place to accomplish it? Because Texas does not, Medicaid does not necessarily cover a lot of assisted living and home health care. Whereas New York State, they cover home health care really well. Washington State covers assisted living really well, right? And so those are huge differences. In Texas, we cover skilled nursing facilities, nursing homes. We have a STAR Plus waiver interest list program, which does do some assisted living and home health care, but the wait list right now is a little over a year. So you have to be able to self-fund, at least in Harris County. Different counties, of course, are going to be different depending on what they have. And again, I'm getting ahead of myself. We're going to talk about this in the next 2 weeks. If you just let me talk, I'll just keep talking. Someone has to stop me.
So please come back next week, everyone. Thank you, Angela. This has always been so helpful for me just to hear the information again. Can't hear it enough. So we really appreciate you today. If y'all have any questions, feel free to email me. Angela also put her contact information in the email, in the slides, and then I will be sending out the recording. So you'll either get it today or tomorrow. So.
Wonderful. Thank you all for having me. Thank you, Shalonda, for introducing me.
No, this was a great presentation. I'd like to throw a little plug in there. Of course, I'm an attorney as well, but just as Angela was talking about, if you think about it, estate planning is not a one size fits all. It's like a health plan, a diet plan, everybody's different. And I think as she was just talking about the intricacies and just the complexities of different situations, I think it's very helpful to have somebody walk you through this process. And then just the nature of life, things change, things evolve. So you want to have somebody that has your information. They're familiar with, you know, they may have already helped you with your will. They may have already helped you with your power of attorney. Then something else comes up, but they'll already have that information. I'll just give you a quick example, then I will be quiet. I did a conservatorship for one of my clients, and there was a form that we, you know, used in the process that he needed to send to the bank, but he couldn't find it. And so he needed to provide it to the bank. So he reached back out to me, and I was able to provide him with that form. So another benefit to having your attorney work with you is if you lose forms or you lose documents or you don't remember what happened, you can reach back out to your attorney. They can assist you.
Yes. Estate planning is not one and done, and it's not one size fits all. And if you're in Dallas, not in Harris County, contact Shalonda. She will help you, right? There's more than enough work to go around. We have to help each other out. And yeah, I'm a big fan of working with other attorneys and just making sure that people get what they need. That's the most important.
Thank you so much. Thank you. It was a great presentation. Thank you. Very informative. I couldn't write that fast.
I will send you the slides so you'll be able to review them. And if you have questions, just
great.
contact my office.
Great. Thank you.
Thank you, everybody. Enjoy the rest of your afternoon.
Yes,
See you
Thank
next-
you.
See you next
Thank you.
week at 12 o'clock, same day, Thursday at 12. We'll see you.
Thank you, Ariel. Thank you.
Bye-bye.